am Marina Cugurra from Innov-acts. I am a lawyer specialized in research and innovation development, as well as an ethics expert serving both for European Commission and the European Defence Agency, as well as external advisor or partner in several European projects. As Brian mentioned, today we will deepen the AI Act, compliance, governance, and innovation. So, this is the agenda. We will start setting the scene and reminding the key milestone and application timeline, implementation, governance, and enforcement. We will go through the key approaches of the AI Act and deep dives and examples. We will also underline the tools supporting innovation and compliance, and we will investigate if the AI Act could be future-proof. So, starting with the environment in which the AI Act was developed, first of all, we can mention the objective of this workshop, which is to explore what AI means for innovators, researchers, and organizations, and which kind of impact these regulatory sources might have on responsible AI development and collaborative intelligence systems, unpacking the core principle, obligation, and implementation parts of the Act, and exploring the timelines and the practical implication, as well as key tools such as the regulatory sandboxes. The AI Act is the regulation number 1689/2024 of European Commission, laying down harmonized rule on artificial intelligence. It is directed to ensure that the AI systems are trustworthy and aligned with European values, whilst promoting innovation and the digital single market, as well as competitiveness. It is the first comprehensive AI law in the world. It is introduced by the European Commission, placing responsibilities and on organizations developing, using, or procuring AI systems, as well as addressing risks to health, safety, and fundamental rights, and protecting the rule of law, democracy, and the environment. The AI Act has an extraterritorial scope, since it applies to providers and deployers of AI systems inside and outside Europe, as long as the AI system itself is placed on the union market or its use has an impact on people located in Europe. The AI Act is structured in 13 chapters, each of them addressing a specific topic, such as governance, such as codes of conduct and guidelines, or general purpose AI models, or high-risk AI systems. In addition, there are 118 recitals, which provide the context about how an article should be interpreted, and 13 annexes, which provide supplementary information alongside the regulation, for instance, on high-risk AI system or on declaration of conformity. But the first thing to underline is the definition of the AI system as provided by Article 3 of the AI Act. It is very important to understand such a definition, since it defines the scope of application of this regulation. This definition is based on a life cycle-based perspective, encompassing two main phases, the building phase and the use phase of the system. It comprises 7 elements, not necessarily all continuously present throughout the both phases. So, an AI system is a machine-based system designed to operate with varying level of autonomy, therefore independently of human intervention, that might exhibit adaptiveness after deployment. This refers to its self-learning capabilities, and that for explicit or implicit objective infers from the input it receives how to generate outputs. The output could be prediction, content, recommendation, or decision, and they can influence physical or virtual environments. In order to assist the stakeholders in understanding the AI system definition, on February 2025, the European Commission provided guidelines on such definition, which assisted the providers and other relevant persons in determining whether a software system is or not an AI system. They are not binding and they are expected to evolve over time in light of the practical experiences, new questions, and use cases which might arise. It is important to place the AI Act within the overall European ecosystem, and therefore to mention the European approach to artificial intelligence, which was initially set by the European AI strategy, which is aimed to promote a world-class hub for artificial intelligence, ensuring that it promotes innovation, but also that it is human-centric and trustworthy, in order that people and business could enjoy the benefit of AI while feeling safe and protected. This is what now is referred to as AI made in Europe. Meanwhile, the European Commission also put in place a set of strategic action and investment to enable the condition for development and uptake of artificial intelligence and for ensure the smooth transition of such artificial intelligence from the lab to the market, promoting and encouraging AI adoption and fund innovation. They encompass different instruments, such as the white paper on AI, the coordinated plans on artificial intelligence, the AI innovation package, and the Gen AI for You initiative, the AI factories, and the funding program Horizon Europe and Digital Europe. And we need to focus on the AI Continent Action Plan, which was launched in April 2025 by the President of European Commission during the AI Action Summit in Paris, to set the course for Europe's AI leadership, transforming the Europe's strong potential into powerful engines of AI innovation and acceleration. It rotates around two main building blocks: competitiveness and productivity, and sovereignty, security, and democracy. And the AI Act is part of this overall strategy. The AI Continent Action Plan has 5 main areas. We can mention, for instance, the computing infrastructure, data, skills, development of algorithm and adoption, and simplification of rules. In this regard, it was recently launched the AI Act Service Desk. On the other hand, we need to mention that a couple of days ago, again, the President of the European Commission launched two strategies to speed up the uptake of AI in industry and science. They are the Apply AI strategy and the AI and Science strategy. The first is devoted to harness the transformative potential of AI by driving adoption of it across strategic sectors, and to put in place to realize AI first policy so that the companies can consider AI as part of the solution to tackle challenges. And the second is aimed at positioning the Europe as an hub for AI-driven scientific innovation. On the other hand, we need to consider in this overall ecosystem where the AI was born, also the ethical sources. In particular, we can mention the ethics guideline for trustworthy AI and the Altai assessment list, both developed by the high-level expert group on artificial intelligence appointed by the European Commission. Such guideline rotates around four ethical principles and seven key requirements to realize trustworthy AI. And we can mention that these requirements are also included in the AI Act itself. On the other hand, it is important to mention a recent initiative of the Council of Europe, in particular of the Committee on Artificial Intelligence, the UDEIRA methodology, which will be complemented by UDEIRA model in 2025 and is a tool standalone, not legally binding, providing guidance for risk and impact assessment of AI systems from the point of view of human rights, democracy, and the rule of law. Starting with the key milestone and application timeline of the AI Act, we can see that this source had an evolution started in April 2021 with the first proposal. Then there were several phases, and in March 2024, the AI Act passed and it entered into force in August 2024. The timeline for its implementation started immediately after its entry into force, where at that stage none of its requirements applied. But in February 2025, some of its rules started to become applicable. They were in particular the prohibition on certain AI systems and requirement on AI literacy. In August 2025, other rules started to apply, such as the governance mechanism, the penalties, and the GPA models. Next year, all the other parts of the AI Act in August will start to apply, except those regarding the classification rules for AI risk AI system and the corresponding obligation, which will start to be applicable in 2027, in August in particular. But in order to ensure a smooth and effective implementation of the AI Act across the EU, in this transitional period, in the time between the entry into force and the date of applicability, the European Commission promoted a voluntary initiative named AI Pact. It is an initiative aimed at helping stakeholders to get prepared for the implementation of the AI Act. It has two main pillars: gathering and exchanges within the AI Pact network, and facilitating and communication company pledges. These pledges, voluntary pledges, are of two kinds. There are the core ones, and all the companies participating to the initiative should commit at least to these three. And they are the adoption of a governance strategy in line with the AI Act towards future compliance, the mapping of the AI system likely to be categorized as a risk system, and starting promoting AI awareness and literacy among the staff. This is the first part. In addition, the participating company also committed to additional pledges linked to other obligations introduced by the AI Act concerning transparency and requirement for high-risk AI systems, such as risk mitigation and human oversight. Moving to the implementation, governance, and enforcement, we can mention that the AI Act has a two-tier governance system. One part is at national level and another part is at the European level in order to ensure a balanced approach. At European level, we have the European AI Office, and at national level, above all, we have the national market surveillance authorities. These two figures are responsible for implementing, supervising, and enforcing the AI Act. In addition, there are advisory boards, which are the European Artificial Intelligence Board, composed of representatives of the member states, the scientific panel composed of independent experts in AI, and the advisory forum composed of a selection of stakeholders, both commercial and not commercial. As regards the AI office, it was established within the European Commission with the mandate to oversee the enforcement and implementation of the AI Act in the member states. In particular, it is responsible for supporting the governance bodies in the member states, but also to supervise and enforce the most powerful AI models, the general purpose AI models. It comprises 6 units and two advisors, the lead scientific advisor and the advisor for international affairs. We have mentioned the main task of the AI office, and we can also remind that it is also responsible to foster international cooperation and the cooperation with experts and stakeholders in the fields. At national level, we have three types of authorities. The member states are required to designate and establish them as part of the implementation of the AI Act. However, there is a large degree of discretion with regard to the structure and design of these authorities. They are of two main typology, the national competent authorities and the national public authorities. The market surveillance authorities and the notify authorities are the national competent authorities. The first is responsible for activities and measure on market surveillance and compliance of product, and it follow a well-established concept of market surveillance authorities within the European law. The notifying authorities are in charge of establishing and performing the procedures for the assessment, notification, and designation of the conformity assessment bodies. On the other hand, the national public authorities are in charge of the enforcement of the respect of fundamental rights obligation in the member states. And in relation to this, they have the power to request and access any documentation. The national competent authority work in close alignment with the AI office and supervise the implementation and application of the AI Act at national level. They should have been appointed by 2 August 2025, but there is some delay in some cases, and the European Commission is supporting the process. They should function independently, impartially. They should have provided with the resources to execute their task, and the European Commission will facilitate exchanges of experiences between the national competent authorities. As regards the national public authorities, as we saw, they are responsible for fundamental rights protection, and they should be involved in AI incidents. They have three main rights: the right to be informed by the market surveillance authorities, the right to request information and cooperation from market surveillance authorities, but also from the providers of the AI risk AI systems. Regarding the advisory board, the most relevant could be the AI board, which is aimed at fostering a coherent and forward-looking AI policy framework that benefit all the European citizens and businesses. There are two additional advisory boards, as we saw, the scientific panel and the advisory forum, which are going to provide valuable insights. On the other hand, we also have penalties for infringement of the obligation and requirement of the AI Act. The member state will have to lay down such penalties in an effective, proportionate, and dissuasive manner. But on the other hand, the AI Act set out the threshold that need to be taken into account. It's important to remind that there is a lower amount for the SME. As regard the rules on provider of general purpose AI models, again, there are threshold of penalties, and in general, the penalties apply also to the European institution. The European Data Protection Supervisor will have the power to impose fines on them in case of non-compliance. Moving to two important approaches of the AI Act, we can see that AI should work for people. In this sense, the AI system must be developed and used to serve human interests, protect fundamental rights, and promote well-being, whilst also being safe and trustworthy. This is strongly related with the risk-based approach and with the trust building. The pillars of human centricity under the AI Act are several. Besides the risk-based approach, we have the human agency and oversight, accountability, transparency and explainability measure, fairness, avoidance of bias, and discrimination. The risk-based approach foresee different level of risk systems, AI system, starting from the acceptable risk, continuing with the high risk system, then limited risk and minimal risk AI systems. The AI systems which are banned because they are unacceptable are those providing a clear threat to the safety, livelihood, and rights of people. There are a number of practices which are prohibited, including, for instance, social scoring, biometric categorization to deduce certain protected characteristics, and so on and so forth. The European Commission provided a guideline to better understand which are these prohibited AI practices. Then we have the iris system, but we will come back on this later on. And then there are the lower risk AI system. In particular, the limited risk system are associated with the need for transparency. The operators need to be informed when necessary to prevent trust. This also includes, for instance, the providers of generative AI, which have to ensure that the content generated by AI is clearly labeled and identifiable. The minimal or no risk system are the vast majority in Europe, and there are, for instance, video games, spam filters, and no specific rules is provided for them. Another important measure in line with the human-centric approach is the fundamental right impact assessment provided by Article 27 of the AI Act. It need to consider the context of use of the AI system, and in order to avoid overlap, in case the providers of the high-risk AI system are also need also to carry out a data protection impact assessment. In such cases, the FRIA shall be conducted in conjunction with the DPIA. The fundamental rights impact assessment should have a clear structure provided for by the AI Act itself, encompassing, for instance, the description of the implementation of human oversight measure, the risk of harms, the description of the deployer processes. The obligation to the fundamental rights impact assessment applies to the first use of the high-risk AI system. The AI Office shall develop a template for conducting this impact assessment, which might also include an automated tool. Moving to some deep dives, the first regards the high-risk AI systems. They are those that pose serious risk to health, safety, and fundamental rights. There are strict obligations and requirements set for such kind of system before they can be put on the market. They include high level of robustness, cybersecurity, and accuracy. They need to be ensure the traceability of results, risk assessment and mitigation measures, and so on and so on and so forth. In February 2026, the European Commission is expected to provide guidelines on this kind of high-risk systems, including also a comprehensive list of practical examples. Here we can have some of the most frequent case of high-risk use case system, such as the AI safety component in critical infrastructure, for instance, transport, the failure of which could put the life and health of citizens at risk. But also we have certain AI use cases used to give access to essential private and public services, such as the credit scoring, deny citizens opportunity to obtain a loan, and so on and so forth. For the AI risk AI system, there are both pre- and post-market obligations. As regard the former, they include the need to undergo a conformity assessment and to comply with the AI requirement. They need to be registered as a standalone AI system in a database at European level, and then there is a declaration of conformity. Once the system is on the market, there are the surveillance authorities in charge of market monitoring. But the deployers and providers need to report serious incidents and malfunctions, and they also have obligations in terms of human oversights and in general of monitoring the system. The conformity assessment is described by Article 43 of the AI Act, and it consists in the process of demonstrating that the high-risk AI system complies with the requirement listed by Chapter 3, Section 2. There are two types of conformity assessment: the internal one performed by the providers, and the third-party process conformity assessment performed by an external independent third party, a notified body. Another deep dive regards the general purpose AI models. In fact, this kind of model, which can perform a wide range of tasks and are becoming the basis for many AI systems, could also bring systemic risks. The AI Act has a set of rules for providers of such models, such as transparency and copyright-related rules and mitigation of the systemic risk. The European Commission launched tools supporting compliance, which should work hand in hand in order to give rise to the clear and actionable framework for providers of such models. They include guidelines, a code of practice, and a template for the public summary of training content of GPA models. Moving to the tools supporting compliance and innovation, first of all, we can mention the recent AI Service Desk mentioned before of the Apply AI strategy, which support a smooth and effective implementation of the AI Act and is expected to provide legal certainty and the single information platform as a central hub where the stakeholder can retrieve all the relevant information. It consists of three main parts: the compliance checker, AI Act Explorer, and online form to ask questions to the AI Act Service Desk. On the other hand, we can also mention that the AI ecosystem of excellence has several pillars, and one of them could be helpful in supporting the compliance with the AI Act. In fact, it is a research and innovation project funded especially under Horizon Europe project which could also regard tools for supporting compliance, traceable and accessible aspect. The previous call in 2024, there are four main projects: Achilles, Certain, Accomplish, and Data Pact. But also in the 2025 call, there will be additional project in this line. Another tool supporting compliance is the codes of practice. These codes are foreseen by Article 56 and will be developed through a multi-stakeholder process. The first of which has already been published and regard, as we mentioned before, the General Purpose AI Code of Practices. It has three main chapters specifically devoted to transparency, copyright, safety, and security. Another important role is played by the harmonized standard in the AI Act. The European Commission gave mandate to the standardization organization Channel Act to develop standard for the requirement for the high-risk AI system, and the compliance with this, the alignment with this standard give rise to a presumption of conformity with the AI Act, unless there is evidence of non-conformity. The deadline for the publication was 30 April 2025, but there is some delay. There is also an inquiry, a very recent inquiry in this regard concerning the development of such harmonized standard regarding the transparency and the lack of a balanced representative of interest in the standardization process. Then there is another tool, which is the AI literacy requirement tool. The providers and deployers of the AI system should take measure to make their staff and other person dealing with the operation and use of the AI system know the basic of these systems, taking into account their knowledge, experience, and education, as well the context where the AI systems are going to be used. There is no one size fits all the solution because different levels of training and learning approach can be appropriate. And the European Commission, thanks to the involvement of the AI Pact community, published the Living Repository of AI Literary Practices, which will be updated from time to time. Another very important part of supporting compliance are the regulatory sandboxes, which should be linked to other of the pillars of the AI ecosystem of excellence, in particular to the TEF, AI factories, and data spaces. The AI Continent Action Plan, in particular, mentions this and the role of the Digital Innovation Hub, AI factories, and the testing and experimentation facilities in relation also to the regulatory sandboxes. Moving to the question if the AI Act is future-proof. The AI Act is a flexible legal framework responsive to new development. It is an easy and quick to adapt tool, first of all, because it is based on a risk-based approach, even though there might be some challenges in this regard because it relates to the reactive risk management system paradigm, focused on foreseeable risk. Another aspect to take into account is given by the standards and the codes of practice, which will materialize the obligations of the AI Act, providing concrete technical solution through flexible tools. Then we have the amendment through delegated and implemented act, which are very important to ensure that the AI Act is aligned with the current technological development. Concluding. In conclusion, we can see that this regulatory source is aimed at building trust and also at stimulating the adoption of AI. It is not expected to be a burden in the long term, despite the initial phase of implementation might pose challenges, especially for SME. Like the GDPR, however, after the initial phase, it could be really useful in the future. It also provides, as we have seen, tools encouraging innovation, such as the regulatory sandboxes, the testing and experimental facilities, and the AI factories. The remaining question is how strong the impact of the AI Act will be outside Europe. The challenges related to complying with the AI Act are significant. Nevertheless, it offers a structured framework for transparent, responsible development and implementation of artificial intelligence, ensuring that these systems are used in Europe in a safe way, in transparent, traceable, and non-discriminatory ethical manner. So now I stop sharing. And if there is any question, I am here.
Well, maybe we'll take a few minutes. If anybody has any questions, feel free to open up your mics and ask, or you can also share a question in the chat. While any questions are being thought of, I just wanted to take a second to thank you, Marina, for the wonderful overview of the EU AI Act, both the policy context, the calendar for the implementation, as well as all of these, I guess, deep dives into the Act itself and the different areas of risk that you mentioned, as well as sharing the financial results. So we'll just give maybe about 1 minute to see if there are any questions.
Hello, I have a question, if I may.
Yes, please.
Yep. Thank you very much, Marina, for this amazing overview, so much information. I was just wondering if you could maybe elaborate a little bit more on the topic of the national competent authorities. sort of I'm interested in sort of knowing what is expected from the from the member states. What type of information, what type of I don't know, AI surveillance do the member states need to do, to contact and sort of communicate with the AI office in the Commission, right? So what is expected from the member states?
Okay. So the member state needed because the deadline has already passed. It was August. To appoint and make operational these authorities, both the market surveillance authorities and the notifying authorities. They need also to provide the European Commission with a list of the contact of these authorities and the contact of each of them in order to make easy to get in contact and to make exchanges with them. So this is the main aspect they need to do in relation to the public authority setting. And then, of course, they will need to operate according to modalities set at national level in line with the framework provided at European level. These are the main aspect. But there is some delay because not all the European countries have appointed the respective national authority, and so the process is still ongoing. As many other parts of the AI Act, there is delay also in the standardization process. There are a lot of delays, but nevertheless, we are moving forward. Thanks.
Thank you.
Brian, may I ask also a question? Actually, I wanted to ask, I will ask this to Marina offline, but because we are in the webinar, I asked her now so that other people listen to this answer. It is kind of a practical question. So for a small company like us, okay, if we are having a new product, a new AI product, or a new AI service. How can we get feedback and advice on whether we are what is our risk level and if we are compliant, if we are doing the right thing? Because we don't want to start developing a product and going in a direction which is not regulatory compliant. So what is the practical step for a company? I would say a small company without too many lawyers and a legal department in-house and AI Act experts. How do we know we are on the right direction, and how do we get feedback that we are officially compliant and we do not have a problem afterwards?
Okay, in my opinion, there are two ways. The first, participating to the AI Pact initiative I mentioned before, because it is exactly the scope of this initiative to start implementing practice, experimenting solution to be compliant with the AI Act. So this is the first and simpler way to get advice and to be supported in this regard. But I could also mention a very important project which regards the regulatory sandboxes, the official ones, not the project level one, which is EUSER. The EUSER project is now boarding for new SMEs to take part to this regulatory sandboxes exercise and have an official feedback from the official national authorities. So I would suggest to get in contact with the EUSER ecosystem and apply for this kind of involvement. So AI Pact and EUSER project for the moment.
There is no such thing like, a government service, or there won't be a government service that gives me official feedback and maybe, a stamp, that what I'm doing is compliant?
I think that this new service I mentioned before will have this role. The AI Act Service Desk will be exactly this, at least partially, because it is not official. It is like the IPR help desk we had in advance for European project. But the purpose of this AI Act Service Help Desk is to support companies, SME, stakeholders, system provider, and so on and so forth to get aligned with the AI Act. So it is a third part. And also the platform recently, it was launched on 8th of October. So we will see how it go ahead.
Great.
Thank you, John.
Thank you, John. Thank you, Marina. Are there any final questions out here? Any final comments from any of our participants today?
Hello. Hi. I do have a question.
Yeah, please.
So first of all, thank you, Marina, for your presentation. It was very enlightening. You gave a very brilliant overview of the EU Act, AI Act, sorry. I just wanted to, I have a question actually regarding your work as a HumAIne project. If you have perhaps some objectives regarding this AI Act, like if you mean to somehow contribute to this act somehow to, I don't know, send recommendations to the European Union in general, or, you know, a way through which your project, the research you're conducting in this topic is also aimed at making recommendations to improve the AI Act, which we know may present some gaps in protection. Thank you.
Okay, thank you for your question. The project is producing material regarding learning material like today webinar and a lot of training modules supporting the compliance with the AI Act, and also in different aspects of the technological development regarding human AI collaboration. So it is very active in this regard, and it is expected to support in the future the implementation of the Article 4 of the Act, the AI literary requirement. Part of the learning material developed under the project in different contexts, as I mentioned, can be used for future uptakers of our solution and beyond. So this is the first part. And then, of course, at the end of the project, we plan to give a sort of lessons learned ethics workbook, which could also include recommendation for the future development and of the AI Act. This is the plan.
Thank you. Thank you very much.
You're welcome.
I would also like to quickly mention that within the project as well, we have a dedicated task related to contributions to standards, associations, and policy development around all kind of related to the project objectives around human AI collaboration. I don't want to share too much at this time because I believe in November we'll have our another webinar session about the work being done in standardization within the project itself. But yes, we have so I guess in November, once we have this next webinar programmed, definitely join then as well to hear more about how we're involved in all of those policy development conversations and how we're involved with other projects as well for this.
Okay, thank you. Thank you very much. Then I'll maybe ask more questions during the other webinar in November.
Great, thank you.